all the technology is up to speed. Really appreciate it.
Happy to do it. We are preparing to go live now.
Okay, great. Okay. Let me know. Are we live? Yep. Okay, great. So this is Civil Law and Procedures Subcommittee of the Judiciary Committee starting its subcommittee meeting on 2/21/25 at 12:34. We're starting 34 minutes late because of the interesting debate we had on the floor. Okay. So what I thought we would do is we would take up the three bills I do not believe are controversial and see if we have consensus, but we have to have a quorum and we don't have a quorum right now. So I'm going to wait again for who just left us.
I left and I came back.
The Delegate Tolles was here, but
Delegate Tolles hearing, but well, I'm just gonna let us know what. So I'm looking at House Bill 788, which is the judiciary's bill to be able to do a temporary appointment. So we're not starting the meeting yet because we don't have a quorum. But if anybody has any questions about it, get them ready because we're going to do that. Take up that one first. We're going to take up the task force to study fiduciary adjudication in Maryland and whether there are any questions or concerns about that. That's, again, the state bar asking to put together a task force that they claim let me just make sure that they're going to pay for. The bill has no fiscal impact and will be run by the state bar. And then the third bill that we'll take up that I believe is non-controversial, well, is relatively non-controversial. There's going to be an amendment that has already been prepared for Delegate Long's bill on guardianship of property of a disabled person. So those are the first three that I'd like to do. I think we can do them relatively quickly as soon as we're ready to go.
I think we have a quorum now.
We now have a quorum. Conaway, can you just give us a thumbs up or something to indicate that you are actually at the meeting? Good, done. You're good.
Can you see me? Come on, man. Come on. Can you see me?
Yeah, you can turn yourself back off if you need to. I don't really care.
No, whatever you need to do.
Okay. So let's talk about House Bill 788. Are there any this is a bill that the judiciary asked us to do to allow them to fill vacancies with people that were already on the committee. They don't need training. They don't need any kind of, it's just a temporary appointment. Is there any questions or concerns about this? All right.
John, I don't remember this one. Tell me again.
Okay. So, yeah, this bill it would actually be this proposed constitutional amendment, if approved by the voters, authorizes the chair of the Commission of Judicial Disabilities to take action in the event of a member's recusal or disqualification or expiration of his term. So as a member leaves, to be able to appoint temporarily somebody, but it would have to be somebody who's already served as a former member in a temporary capacity until a new member can be assigned to it and appointed properly by the governor.
But can't they do that now with retired judges?
So according to the testimony, this was testimony of Judge Fader, they cannot. I believe that they have done it, but they're not sure they have the authority to do it.
So they want to codify what they're already doing.
I believe so.
That's right. And I'll just add in here, Delegate Cardin, it says in the fiscal that any vacancies on the commission must be filled by the governor in the same manner as for making the appointments. And so what I guess is happening is there are vacancies that can't be filled.
Right. They're just
and this would create a buffer.
Right. So the vacancy just stays there until the governor appoints it. This would allow the judiciary to have somebody in a temporary capacity.
And the way they've worded it, could it be anyone that was not already a sitting judge.
So Holly, you might want to chime in.
Sure.
I believe it can be anybody who has already served on the Judicial Disability Commission in a former capacity.
Yep, that's right. Any former member to serve, or they can request the governor to appoint a member or extend a current member's term to fill that vacancy too. So they can request the governor to appoint somebody to fill it, which they can do now, and that's what happens. Or they can recall a former member, or they can ask the governor to extend a current member's term to hold the vacancy until the governor appoints a new person.
Okay.
Any other questions? Okay.
Wait, I have one, sorry.
Oh,
So sorry.
Sure.
Can you just tell me how long that the appointment's gonna be for, the temporary appointment? What's the maximum?
It will be until the governor appoints a new person to the commission. It could be, I mean, if the governor chooses, I mean, so I mean, it can be, it could be for the
So indefinite.
It could be for the duration of that.
So there are, I'm just going to chime in here. There are some rules. So a member may not serve for more than 2 4-year terms or for more than a total of 10 years if appointed to fill a vacancy. So it sounds like if they're just doing holding a spot, they're still probably going to be subject to those term limits. But the governor by that time is probably going to fill a vacancy because that person's just holding a spot. If that helps.
Okay.
Delegate Williams.
How long-
I'm sorry. Delegate Erican, did you have another question?
I was gonna say, how long does it usually take? I feel like the governor is usually pretty quick, but there's no incentive really. You know, if the position's essentially interim filled, there's no incentive for, I mean, not this governor, but a future governor might just be like, well, I like the person in there now. I'm not going to appoint anybody new. Do you know what I mean? Where's the incentive to get him to appoint somebody new or her?
So, I mean, my response to that is if the governor likes the person who was appointed temporarily, then the governor should then make it official and appoint that person and that person has the ability to serve the number of terms permitted by the rules. It would seem like, or if the governor doesn't want that person, the governor should then appoint somebody to replace that person.
What if they've
So-
aged out? Does this allow him to use in an interim appointment, like somebody who's already aged out?
I believe that it's only somebody who is qualified to be able to serve in the position. So if
Okay, so
Chair
not like how
Cardin?
we have like the temporary
Yeah,
floaters.
am
I
I-
have somebody that can speak on this bill. Do you want me to bring them in?
Sure. In fact, I told them that I didn't think we needed them, but sure, I would love to have.
Okay, give me 1 second to get them the Zoom link and they
Thank
can
you.
hop in and
While,
help with some of
while
the
you're
questions.
while you're doing that, Delegate Williams, did you have a question?
No, I just wanted to confirm that we were on House Bill 788, which it sounds
Yeah.
like that's what we're talking
Yes.
about. Okay.
Yes, Delegate Embry, did you have a question?
The chair.
Oh.
The chair.
Yes.
Can you hear me? Can you hear me? Yes, yes. No.
There's some feedback on your end, Delegate Toles. When you speak, it's like
Okay.
reverbing back and forth.
Can you hear me with this computer?
Oh, that's
Yeah.
better.
Okay, thank you. I had to use my cell phone because I was having issues where I couldn't hear you all and you couldn't hear me. Okay, thank you.
Okay. So we're going to we'll see if we can get somebody on quickly. While we are waiting, because I don't know how
Hunter, we're waiting. She should be hopping on. It's Kendra from the JDC.
long. Okay, great.
Okay, I'll let her in as soon as she joins.
Thank you, Hunter. I did not expect her to need to be on here, but that's great. Okay. Do we want to go on to another bill while we're waiting for questions? Is that okay with everybody?
Yes.
There's a problem with that. Okay, then let's go to House. Yes, Delegate Conaway.
Thank you very much, Mr. Chair. So I just want to be clear. So I've been on several Zoom meetings and several committees. Are we supposed to be live and video when we're on these Zoom meetings? Because if you're driving, I guess you were supposed to pull over so you can be on live, or, I mean, I don't know what the rule is.
We,
I'm
we
asking-
are, I think per the rules that the chair set up, we're supposed to be on camera in committee. In subcommittee, I don't think that rule has been established. I would ask that if you're going to ask a question and you can get on camera, it probably makes sense to do that. But as long as everybody is engaged, so that we have a quorum, I personally
So we
don't
need to
really
be
care.
on camera to make sure that we have the quorum. Is that what you're saying?
No, I'm saying that as long as everybody is engaged and paying attention, I'm not really, so that we have a quorum, I don't care whether your camera's on or off.
Oh, I thought you asked me earlier, could I cut my camera on?
I just want to make sure, no, I just want to make sure that could hear us. That's all. You can turn it back off. That was what I was saying, is that? Okay,
Thank you.
you're welcome. Okay. All right. Any word from the Judicial Disabilities Commission? Are we still waiting? Okay.
Not here yet.
Okay. Let's go to House Bill 315, Task Force to Study Fiduciary Adjudication in Maryland. Did anybody have any questions about this bill? Again, the fiscal note indicates that it will have no fiscal impact. That was my concern when I put the bill in. And it is simply a task force to study fiduciary adjudication in Maryland, and whether the way we're doing it is the right way, if there's any recommendations as to improve essentially how the Orphans Court issues operate. Yes, Delegate Embry.
I'm supportive. My memory is there was a need to conform to the Senate bill. Is that right?
Yes, and you have those amendments. They're in that email, and the reprint is with the amendments that the Senate made. It's a Register of Wills amendment and an MSBA Estates and Trusts amendment.
Right.
Conway, Register of Wills Amendment.
Mhm.
What does the Register of Wills Amendment do?
Holly, is it technical by nature?
No, give me 1 second. It was just clarifying the members on the task force. So, let's see. It's yep, it adds 2 registers of wills designated by the president of the Register of Wills. So right now, without the amendment, it says the chair of the Maryland Register of Wills. This cleans it up and says 2 Register of Wills members as designated by the president of the Register of Wills.
Mhm.
Okay, moving forward, can you let me know any bills that I'm asked to be part of that
Right.
involve the Register of Wills office, please?
So-
I need to, thank you.
Of
Right.
course.
So this bill does have the Register of Wills is involved with it, or so if you do want to take the rule, if you feel
No, if
that's
you're telling me I don't have to, as I
I
understand,
don't believe you. I don't believe you have to, but that's your
as I've
decision.
been
not mine.
told, I must. No, as I've been told, I must legally.
Okay, Delegate Williams, did you have a question?
I was
Right.
just gonna move favorable.
Okay, can we then the amendments, which again are clarifying, and
Oh, do I need to move the amendments first? Sorry.
let's move the amendments.
Move the amendments.
Second.
Okay. Anybody oppose the amendments? The amendments are going to pass. Okay, the bill as amended.
Move favorable.
Second.
Any other questions or debate? All right, all those in favor of of House Bill 315 with the amendments indicate with either a hand. Very good. Is there anybody opposed? All right, and Delegate Conaway, you want to stay excused on this? All right, very good. We'll just I'll find out from him. Very good. House Bill 315 is done. I believe that we have the young lady from the Judicial Disability Commission on the line. So let's go back to House Bill 788. Okay. There were some questions about the extent to which the person could serve if the governor fails to appoint somebody new. And whether somebody who's been aged out or has already used up all of their time on the commission is permitted to be able to be chosen to come back and do more, even though they've used up all their time. So those were the two questions maybe you can help us with.
Good afternoon, Mr. Chair and fellow delegates. I'm Kendra Jolivet. I'm the Executive Counsel for the Maryland Commission on Judicial Disabilities. So I heard a couple of the questions, and I wanted to share with you that the reason that we want to do this is primarily for public hearings. So we've had issues where we've had public hearings and we've only had one judge because the other judges were disqualified or recused for whatever reason, or were no longer on the commission. And although this can happen in any position, this can happen for the public members as well as the attorney members. But primarily we've had the issue with the judicial members. And we wanted to make sure that if that were to happen, that we would have the ability for the commission chair to appoint someone who was previously vetted by the governor and by the Senate to sit for that period of time. So it would be very limited. And I believe that was one of the questions there. It would be for that particular time period or purpose. And primarily, we are looking for the public hearings and that process.
Great, thank you. Delegate Arcand, did you want to follow up with that about, you're good, okay. Any other questions? Delegate Phillips?
So does that mean, is it just for public hearings, or so it's not just for public hearings?
It doesn't have to be. No, that's the reason that we are asking for the legislation. But, you know, there could be a time where if we had a meeting and we don't have any judges or any public members available, so we may need the commission chair to appoint someone in order to meet the quorum, which we have to have at least 6 members to have a quorum. So if we weren't going to have a public member available, we may need to temporarily appoint someone for a particular meeting or purpose.
Got it.
All right. Any other questions? Great. I'd like to hear a motion for House Bill 788.
Move favorable.
Second.
House Bill 788.
Okay, great. Everybody in favor of 788, please raise your hand. Is there anybody opposed? Great. All right. And I'm assuming that Delegate okay, great. All right. Moving
Thank you.
on to the Delegate Long's bill. I believe that Bob Benton is in the waiting room. He was having some trouble getting in, but I believe he wants to make sure that he's available because there were some amendments that we are going to be providing. This bill, for those of you who does anybody need to know what the bill does? This is House Bill 756.
Yes, Mr. Chair, if you could just give us a brief description of the bill.
Sure.
I appreciate it. Thank
Very
you.
good. So this bill, this is a very similar bill to the one from last year, although Delegate Nkongo, you weren't here last year. So this bill authorizes a petitioner who's filing for a petition for guardianship to have all other requests stayed or civil proceedings stayed, meaning that they would actually be stopped. People couldn't proceed with civil proceedings against the petitioner or the guardianship until that guardianship was fully established. That's what the bill does. If you need more information about how guardianships work, we can certainly provide that to you. Delegate Long is here to answer questions. Delegate Long, did you want to just chime in and make sure, because I was not very artful with how I.
Sure. And just to make sure I'm brief and not belaboring the point, essentially, there have been a lot of instances where there have been individuals who are alleged to be disabled, and they're waiting for the court to appoint them a guardian. And there have been many instances throughout the state where they have had the resources, they've had the funds to either pay their rent or to pay their mortgages, but because legally they had not had a guardian, the guardian was not able to step in and to be an intermediary in that particular fact. And so folks have lost their homes, been evicted, been placed at the elements. And what this would do is just put a temporary stay on any foreclosure or any eviction for an alleged disabled person for 90 days or as long as until the court appoints the guardian to help take care of any of the outstanding matters.
So actually, and the 90 days is actually going to be an amendment that's being proposed. So at the end of last year, we did finally come up with language that worked. Everybody was on board. The Bob Benton, who represents the bank, is it the bankers? Is this a banker issue? The bankers wanted to make sure that this was going to work with how they handle civil proceedings. And then legal aid wanted to make sure that there was a technical amendment that was also done. So Holly, can we talk about the legal aid amendment? Oh yes, Delegate Williams, did you have another question? And then Delegate Schmidt, I apologize. And then
So
we'll
my
talk about
question
the
might be answered when we go over the amendments,
okay.
because I
Delegate,
was looking at the letter from the judiciary that just wanted clarification about
okay.
the wrongful detainer action being stayed as well in these situations. And I wasn't certain if the amendments also took care of that concern.
All right. We'll figure that. We'll get that answer as quickly as we can. Delegate Schmidt, you're on. You're not. We can't hear you, or I can't hear you. Can anybody else hear him?
No.
Can't hear you. Maybe you need to stop and restart or something. We won't vote before we get to you. But can Holly, can you just describe the amendment from legal aid? That's the more
I
simple
haven't
one.
seen that amendment, so I would like to understand what it does.
Mr. And we talked about it the other night. It's just a very simple amendment. The issue was, if you look at the bill, it right now says the petitioner may request the stay. In some of these situations, the petitioner might be hospitalized or might not be able to request the stay. And Delegate Long might speak on this a little bit more because I think legal aid spoke to him about this. The amendment would change it to say a party to the guardianship may request the stay if the petitioner is unable to request it themselves.
So if the petitioner is unable to speak, which is maybe part of the reason for the guardianship, or unable to write, and then there's a power of attorney, or there's the person who's proposed to be the guardian who's helping with the legal matters, then that person should be able to, as opposed to the petitioner himself.
That sounds okay to me. I'd like to see the language, but it sounds okay to me. So maybe before it comes in front of the full committee,
Is it?
It's in the reprint, Mr. Enton.
Oh, it is okay.
Yep, it is.
If it's in the reprint, I'm fine. I'm fine with the reprint.
Okay. Is there a motion on that amendment to change from petitioner to a party to the guardianship?
I move the amendment.
Second.
Second.
Great. All those in favor of the amendment, raise your hand. Great. Anybody opposed? No. Conaway is in favor, I guess. Yes.
Yeah.
Okay. Very good. Now the second amendment is a little bit more complicated. Last year we came up with language that that everybody agreed to, including Enton's client, and so that is in the reprint. And one of the changes to the original amendments from last year is that instead of it being 60 days, it is 90 days, which everybody has agreed to. So there's a 90-day that the stay would be for a maximum of 90 days, or until the guardian was appointed.
All right, 90 days instead of 60. That was fine.
Are there any other questions? The other question that Delegate Williams had was, does this help deal with the detainer issue that the judiciary brought up?
Yeah. And the judiciary was just asking whether or not we need to have the wrongful detainer action listed in the list of, I guess, matters that would be stayed, just because the whole purpose of the wrongful detainer action is because the person is unlawfully or allegedly unlawfully in the property. And so, anyway, like I said, I'm reading through their letter. I think we passed this bill last year out as it is with the wrongful detainer language in it. I don't know, or is that correct, Holly?
Is the wrongful detainer language in the amendment, in the bill?
So it is in the bill, and it was in the bill last year. It's not part of the amendments. It's going to be on the top of page 2. And yeah, the judiciary wrote an comment paper on it, just flagging that. But again, that might be a Delegate Long if he wanted to chime in there. The bill came in as it passed through the House and was about to pass back out of the Senate. But unfortunately, I believe it died right on Sunny Die, or right around Sunny Die.
So we just ran out of time last year.
Exactly.
Okay. I have a comment on that, but let's go to Delegate Grammer and then Delegate Conway real quick.
Thank you, Mr. Chair. So I wanted to ask, I think this is a good point to kind of just say how this process will integrate with the current foreclosure process, which is quite an extensive process. Can someone just articulate that for me?
Well, let me take a shot because I'm involved in the bill because of foreclosures. And once again, I think from our point of view, and I work very closely with the foreclosure bar, we wanted some time frame in there. Last year, we agreed to 60 days. The sponsor said, could we move that to 90? I said, okay. So I think unless up until the time you file this kind of emergency petition, someone's appointed, but if a permanent guardian's not appointed within 90 days, then the stay is lifted and the foreclosure could proceed. That's my understanding.
Yeah. Okay.
Gotcha. And very briefly, so like the warrant of restitution under 8401 of the real property article, that's squatters, right?
That's in the landlord tenant article.
Yeah, but the warrant of restitution, that if I'm hearing correctly, warrant of restitution is not necessarily a foreclosure action. It's when someone's.
Oh, no, it's a landlord tenant.
That's landlord tenant.
Yeah, and you described it as squatters. It's actually just holding over.
Yeah.
Or it could be just holding over.
Could be holding over.
Could be holding over, could be squatters.
Could be.
Depends on how you define squatters, but typically not.
And I will tell you that it will be very, very rare that somebody would use a guardianship petition stay in order to try and manage to stay in a as a holdover for an extra couple months. The cost and the amount of paperwork to do that is far exceeds anything that the benefit would come out of it. In my opinion, I don't, but Delegate Conaway.
Yes, I was wondering, could you explain the wrongful detainer so a little bit more?
So I think the issue with the judiciary is because this is a wrongful detainer is usually because of an illegal action. Why is it included in this? Because it wouldn't be something that should be part of an appropriate civil action to stay, especially if the person is trying to illegally take control of your house. That would be, I think, what the judiciary is saying. My comment to that, which you bring up a great point, is that may be something for Delegate Long to discuss with the judiciary for next year, if appropriate. If it's not appropriate to be in the code, and there has been some sort of inappropriate action taken or something that the judiciary felt was bad, that may be something to just fix this bill with next year if necessary. That would be my reaction to it. That we passed it. The judiciary is not all wound up. They were just suggesting that maybe it's superfluous and maybe it doesn't need to be in there.
Yeah, it's not that big of a deal, I don't think.
Could I chime in, Mr. Chairman, just to say that I also represent the Maryland Multi-Housing Association. I think neither this year or last year they weighed in with this bill. I know I haven't shared the amendments with them, but I will go ahead and do so just to make sure they don't have a problem with.
Thank you. All right, I'd like to, because we've now spent a lot of time on this. on the amendment, I'm going to call it the Enton Amendment. I'm going to give you credit. You're never getting any more credit from us again this year. But on the Enton Amendment, is there a motion?
Move favorable.
Second.
Okay.
Second.
All
Thank you,
those,
Dr. Williams.
all those in favor of the amendment? Okay. Anybody opposed? Great.
I'm sorry. This is for Delegate Long's bill?
This is Delegate Long's
Okay,
bill.
are
This
you
is the-
okay with that, Delegate Long? I'm sorry to chime in. Okay, thank you.
This
I
is
was,
the amendment that changes it to 90 days instead of unlimited, and it conforms it to what we did for all intents and purposes last year. Okay, very good. On the bill as amended.
I
Motion?
move favorable.
Great.
Second.
All those in favor? Great. Is there anybody opposed that wants to be listed in the opposed? Okay, great. Okay.
Delegate Carter, if I could, I'd just like to make sure everybody knows that here's something I am in favor of.
Fair enough. All right.
you earned a couple of brownie points with us.
Thank you.
Not a
I'm
lot,
signing
though,
off.
Bob.
Thank you.
Thank you.
A little crumb, a little crumb.
All right.
It's all because of Delegate Long. That's fine.
We have
Thank you.
we have I'm not sure we're going to get to Delegate Foley's bill, and I told her that we might not get to hers since we discussed it last week, but we might. That'll be at the end. But we're going to go right now to Delegate Embry's bill, House Bill 623, which is also dealing with public notice. Delegate Embry, do you want to quickly, for those of us who you and I have been talking about this like for 2 days straight, but everybody else maybe doesn't remember.
Hunter, do you want to bring in Chair Cardin, Aaron? Or no, that's not
No.
McFarland, I'm sorry.
Yeah, McFarland. And is there anybody else that we have for this bill? No, I think that's it.
He might have brought a couple. We could ask Byron.
Right.
He might have brought a lawyer from the.
Byron, did you
bar.
bring anybody? He's still coming in.
Yeah.
We can ask him. Okay. Do you want to quickly describe?
Yeah, thank you, Chair. So you may remember this bill because it was vetoed by the governor, which is an unusual thing to have happen. This bill applies to 1 out of, I think, 200 places in Maryland code where we require notice. And this notice is required when someone is going through probate on behalf of someone who's died, usually a family member. And we currently require that notice be published in a local newspaper, printed hard copy. It costs between $100 and $500 in the $200 to $300 range is most typical. This bill predates the internet by decades. And so the registers have created a website, one statewide website that everyone can use. It's free. And so the bill would eliminate the notice requirement, or eliminate that the notice requirement be in a local printed paper and allow the website. I still, I think that's the best way to go because I don't know why we want to charge Marylanders money that we don't need to. But Delegate Carter and I have been talking about, is there a reasonable compromise that this subcommittee might be interested in hearing? And so Byron, who's the Register of Wills for Howard County, came up with an idea as a compromise. Again, I'm still would prefer the bill to pass as is, but if the subcommittee is interested in a compromise, I'll let him discuss it. I think it's a really smart idea.
And Mr. Register of Wills, did you bring somebody with you that Hunter said he can let in one more person if you have anybody else? I don't know.
If we could have either so Alexis Burrell Rohde, the Register of Wills for Baltimore County, is with us. If she could join us, would be great.
Great.
We also have a couple of attorneys. Whatever the committee would like to, whoever you'd like to hear from.
Okay. Well, if we have specific questions, we can see if we need them. Very good. Okay. Why don't we, do we want to take questions or do you want to first talk? So I will just say that I thought maybe there's some sort of compromise with small states versus larger states, but I know small states are a term of art. And so when I was thinking of small states, I wasn't necessarily thinking of the $50,000 state, which I think is in how you guys define them, but like smaller estates where the money may actually have a meaningful impact versus a $150,000 state, which a $300 fee might not be as meaningful to, for example. That being said, why don't we have Delegate Grammar, you can ask a quick question and then we'll take that and then.
Well, can I just, if you, I mean, Mr. McFarland can explain it better, but his proposal, the size of the estate is possible. It's a little complicated for them to administer. And his idea was that because the notice goes out to two categories of people, creditors and heirs, and creditors really don't care. They're they're nationwide credit card companies and banks. So they really don't need a local paper. Heirs, maybe there's an argument. So Mr. McFarland suggested we require printed notice. Again, if the subcommittee wants to compromise, we require printed notice only if there are basically unknown heirs outside of the heirs known within the family.
Right, and that reduces.
And he can explain it far better than I can. But
that'll reduce it by about half the number of notices required outside of the Register of Wills notice. But and that is easy for you guys to determine.
Easier, but I'll turn it over.
Go ahead, Delegate. Byron, why don't you talk, or Alexis? Either one.
Well, thank you, Delegate Cardin. Just very briefly, I'll just echo what Delegate Embry said, which is that our strong preference is that the subcommittee and the committee and the legislature pass the bill cleanly as it is now, as you did last year. You obviously had an opportunity this session to hear from the publishing industry. They were present at the hearing. I know that you have been working with them on other legislation. I feel like what the governor was asking for in his veto message has been satisfied. I don't believe there's any reason to think that having a second bite at this, where the publishers had a chance to weigh in, I don't think that we have any reason to believe that the governor would veto the bill again. I think that I think you've done your due diligence. So we would prefer you pass it as is. But what Delegate Embry was just discussing was, if we were to try to find some kind of compromise, what we could do, instead of basing the notice on the size of the estate, base it on who the heirs are, and basically allow for kind of like nuclear families where everyone knows everyone and there's no concern about an heir not receiving notice. Let those estates publish on our newspaper or on our website. So, for example, allow people who, if your heirs are limited to your spouse, your children, and your parents, no one, usually when someone passes away, you can identify those people very easily. We do have issues sometimes when you get out to more distant relatives. So if someone dies and their closest blood relative is a cousin, for example, that's where the family connections may be more tenuous and there may be some kind of rationale for continuing a print notice. I don't think so. We, again, would prefer that we just pass the bill as is, but that is an alternative that would be easy for us to determine when an estate is opened, just as we make lots of different determinations when an estate is initially opened. And that would reduce the total number of notices in the state by about half.
Okay. All right. We have a couple questions. I appreciate it. Let's go with Delegate Grammar. I know you were chomping the bit earlier.
Thank you. I just want to be clear. Are we debating two bills, the difference between passing one bill or the other, or passing this bill cleanly, like House Bill 74 cleanly? What do we want to be clear what we're debating here?
May I? So it's this bill cleanly or this bill with an amendment?
Okay. And the amendment is depending upon how we want to define large estate. And that's kind of what's up for debate.
Well, actually, that's one possibility, but the registers think it would be easier to amend it to limit it to distant heirs, I think is the best way to describe it. So we would, if for sort of the nuclear family heirs, we would not require printed notice.
Can you tell us how often we put something in publication that actually results in an heir showing up and making a claim objectively?
Delegate Kramer, that is a great question, and the
only question, right?
And the answer to that is zero. We have combed through our records to try to find a single example of where someone has called one of our offices or contacted an attorney and said, I am a bona fide interested person in this estate. I was entitled to notice. I didn't receive it, but I read about it in the newspaper. And this is using the collective knowledge of all of the registers and the Estates and Trust Bar, who have a lot of experience. One of the registers has been in office since 1978. So we're talking about a lot of experience, and we can't find a single example where that's happened. So the point is that these notices are not reaching their intended audience. And that's why we would like to see the bill pass, I think, cleanly is our preference.
Okay. Do other states do this?
A couple states have taken the lead on moving legal notices to a government-run website or to local government websites, and that's Connecticut has done that for probate cases and for probate estates, and Florida. In Florida, all legal notices are run by local and county governments.
I feel inclined to let the devil's advocate have a moment. Ms. Snyder, do you want to chime in here?
Absolutely, I want to chime in here. I think that I think the bill should receive an unfavorable report. I think this is going to be very detrimental to, it's a huge small business effect. We talked about that in committee. I think identifying to the community at large, not just heirs, not just creditors, but the community is an important process and need. And I think if you would choose to do the amendment as Delegate Embry is suggesting, that says unknown heirs here and not some there, you're fracturing the notice. So you're saying, look for, if you're interested in this, look in one place for one type, look in another place for another type of notice. And I think it is bad public policy. Government has a duty to reach out to the wider community, not just heirs, not just creditors, but the community, to serve this notice. And it really will have a huge effect on small businesses in literally every jurisdiction across the state. I urge an unfavorable report on this. This is bad public policy.
So I have another question, if it's okay, Mr. Chair.
Sure, go ahead.
So, Ms. Snyder, I mean, I kind of suspected Mr. McFarlane was going to tell us there are not very many people that come because they saw something in a local newspaper. I'm disinclined to have the amendment. We should probably either just pass it as is or kill it because we don't agree with it. But like, what's the counter argument to that? What's the value aside if nobody's being identified here? You know, Delegate Embry made pretty succinct point in saying we probably shouldn't incur costs on people that if we're not actually getting the result back of having people come out of the public and make these claims. Persuade me otherwise.
If you follow that reasoning, then why are you posting it on a website? Like, why are you doing anything? You know, if you're just saying, oh, well, we know who the heirs are, we don't know who the heirs are, then there's always cost. You know, I think it is such a specious argument to say the registers are doing it for free. They are not doing it for free. That is rolled into the cost of the registrar's office. They have to maintain a website. The Press Association already does that for them. There are always costs associated with publication of any type of notice. And I think that it is important just to keep it, when you're saying you have a notice served through a website, you are cutting out wide swaths of the population who are not looking on the Register of Will website for anything. You know, I think that we believe that there is a real need to make sure that the wider community is served here.
All right, let's go Delegate Conaway. Thank you.
Thank you very much, Mr. Chair. It's my experience that in some cases, people have children maybe in a previous wedlock or out of wedlock, and they might be in a whole nother state, but they have family in this state, and the family becomes aware of the death through a notice in the newspaper and contacts that person who's the what you call a strange child, and they show up at the funeral and claim their portion. So I just wanted to interject that.
Wouldn't you agree?
Wouldn't you?
Okay, Delegate Arikan.
I'd like to move favorable on the clean bill.
Okay. All right. Well, before we do that, let's see. Delegate Williams. Did you have a question?
Sorry, I was playing around with too many apps on my phone. I did have a question, and now I just lost my question. I should have wrote it down. So I guess this is my thought. So we have this bill before us. This was House Bill 623. And we have another bill that we discussed last week, which was House Bill 74, which I feel like, and maybe I just want to make sure I'm not conflating the two. This is dealing with notices for states and trusts and how those notices are published versus Delegate Foley's bill is dealing with notices that are published by government entities. So they're two separate things, correct? I just want to make sure okay. I see
Yes,
Ms.
that's
Snyder
correct.
shaking her head, yes. Okay.
So, and I think you raise a good point, which is perhaps we should think about both these bills and the consequences of them, and the both positive and negative and potential unintended consequences of either of them together. I don't think we're gonna have time to vote on both the bills.
Okay, but I just want to make sure they're trying to capture two very different things.
Let's go Delegate Tolles real quick, and then Delegate Phillips before we make any other.
This is I think maybe a little bit of a sidebar from what we're actually trying to do here with this particular bill. So I know that Mr. McFarland and I talked about this just being there in perpetuity, and I guess I had some challenges there with that. I do also agree though that some notification is needed, just because, not so much because you know, we're limited to the heirs and individuals who, you know, can make a claim on the estate, but you're dealing with folks that are just older and just read paper. You're still dealing with some of that sort of population.
Real quickly, Byron, did you want to comment?
Yeah.
Yeah, and I appreciate Delegate Tolles having a conversation with you. I think what I want to come back to is what Delegate Embry said during her bill presentation, which is that this is the whether it's a print notice or notice on our website, that is above and beyond what we already do, which is send every interested person in an estate an actual physical printed notice in the mail, and we get to all of those people. So if someone is getting their news from print, that's fine. The people that we're actually trying to reach are people who are going to get a notice in the mail anyway. This is a very specific kind of notice. This is not a notice. I mean, as a matter of law, this is not a notice that is intended for everyone and their mother. It is intended there's this very specific audience, and it's unknown heirs and unknown creditors. And so those people are going to get their notices in the mail.
Great. Delegate Phillips.
Just in the interest of time, Mr. Chair, I'm just going to ask that we hold the bill. I'll request a hold and ask that we bring those two bills back together.
Okay. Well, if we're going to do that, and we haven't had a second on the original motion from Eric yet, so that's fine. The question is, Byron and or Alexis, perhaps you can help us with drafting an amendment so we can just look at it. I know that you're not in favor of an amendment. I understand that. But if you can help us with drafting an amendment so that we can see, so the committee can see the difference between what it would look like with a full unclean bill versus a bill that might impact close to 50% of the estates that you're dealing with, that would be really helpful. All right, we're going to hold this. We're going to bring it back with the other one and have some more time to discuss. Everybody think about your questions. Delegate Conaway, we're holding the bill, but did you want to make a comment?
Yes, I was making a comment on what was said earlier about the known heirs. And my concern is, what about the unknown heirs?
Right. And that's exactly what I think Byron was saying, is that if there is a sense, and they can pretty well kind of dissect the estates to determine if there's likely to be unknown heirs.
How would you tell from my estate?
Well, why don't we let Alexis or Byron again discuss that in like 30 seconds, and then we can move forward.
So in my experience, the newspaper, you publish it we in Baltimore County use the Maryland Daily Record. And I have to tell you, the general population is not really reading the daily record, although it does count as legal notice. What happens most of the time is someone sees an obituary online. If they were sort of intentionally and nefariously left off the list of interested persons, like someone's, estranged from a sibling and intentionally leaves them off of a list of interested person, they'll find out about the death through an online obituary. They won't find it from reading or looking at the Daily Record website.
And I just want to focus back to, is it easy, Byron, to determine whether there is likely to be unknown heirs in a particular estate?
Yes, I mean, when either an attorney comes to us or a member of the public comes to us, we sit them down and we look basically through the family tree to identify who the heirs are to make sure that they've received notice. So that's an easy part of the process for us.
How do you know who a person's children are if they don't tell anybody? What family tree are you looking at?
So I'll try to be as brief as I can, Delegate Conaway. If there is your example, the child from another relationship that's living in another state, is that child likelier to read about this notice by going online? And if you Google Maryland estate notices, we're the first Google search that comes up, or by reading about it in the print edition of the Cecil Whig. I mean, it's more likely that they're going to read about it
Maybe
find about it online.
That knows what happened or that their relationship is, sees it in another newspaper, and like the Sun or the Afro-American. I think they print obituary. But okay.
All right. I would like to see language and figure out, Delegate Embry, if this is if it's something that the committee should consider, whether we should just vote it up and down. So maybe we can do that. We'll hold it till the next time we meet, and then we'll go from there. Great.
Thank you.
All right. We have kept Claire on here for the entire hour, well, almost an hour. I want to go back to, because I really want to try and get to 261, but let's talk about 392 for a little while. Claire, thank you for being on. 392 is a bill that we heard last year. This has to do with two-party versus one-party consent on oral communications, and changing it to a one-party consent for housing authority and housing violation issues. I want to get a sense from the committee. We're not going to vote on it today, but I just want to get a sense. Thank you, by the way, Alexis, and you can stay in the waiting room.
Yeah, I'm trying to figure out how to get out of the meeting. I'm sorry.
You can just turn your camera off and just do it that way. That's fine. Okay. I would be interested to see if anybody has any strong feelings about this bill again. We heard it last year. We heard it again this year. Is there anybody who wants to comment as we start the conversations? Yes, Delegate Brammer.
Yeah, thank you, Mr. Chair. So there's been, of course, a few wiretapping bills, and it's seemed to have been the feeling to get away from doing away with two-party consent. I have the wiretapping bill, and we've gotten, this is the third year we've worked that. We've gotten away from exempting certain crimes from the law, and moved towards an admissibility of information language in that bill. So from my feeling is, I like two-party consent. I like that it protects privacy. We don't get many charges of the wiretapping law. It seems to be that most people want to fix the problems without kind of attacking two-party consent itself. I'm a big civil libertarian personally. It's an awkward mechanism to kind of defer an authority to like a nonprofit group as this does and say, for this one particular mechanism, we're going to allow you to violate the two-party consent that we have to protect privacy. So it's a little police statey. I'm actually surprised to see it come up. I'd much rather protect two-party consent and find some other ways to deal with these infractions.
Great. Okay, Delegate Erican, real quick.
Yeah, I would echo all of those concerns and just say, there are so many other really, really serious crimes that we have no carve outs for. This just feels like a totally obscure thing to violate two-party consent on. I'm equally as shocked as Delegate Grammer that this bill is even in subcommittee, frankly, because it doesn't make any sense to me why we would start to chip away at that, since I think both parties, I think, support two-party consent pretty broadly in the state. So there's no edits, I don't think, that could make this bill tenable for me if it still includes essentially a blatant violation of two-party consent policy.
All right, Delegate Schmidt.
Thank you, Chair. We've heard this bill for a number of years. The big concern for me is we asked some of the nonprofits, some of the people that were working these cases. It's almost like quotas in the police department, and that's why I'm against the bill. So just wanted to share that. That was one of the compelling pieces of information that I heard during the testimony.
All right. I will comment that I remember, unfortunately, I was not here for the entire hearing this year, but last year I was. And there was concerns about training. There was concerns about the difference between police officers and people who do this for a living versus picking and choosing sort of people who this is not their everyday business, and that was a concern. I know that I'm sure that we have a couple of people on here that can comment to that if that's a concern that anybody else has. Okay, Delegate Embry.
I just wanted to say I totally agree that we should be looking broadly at two-party consent and all the different aspects. I do support this bill though, because I think it's I think the value of it from a policy perspective is worth it. And I think, these are commercial interactions, so I think it is limited. And these are people who are trained in having asking the questions that, would be recorded, and it is the best evidence. But so I just want to say that. Thank you.
Delegate, and we do have Aaron Greenfield and Hugo here to answer questions, by the way. They are opposed to the bill. Only going to answer questions if there's something to chime in on, but let's just see what else we have. Delegate Phillips, because I'll give Grammer a second bite.
So I think I am gradually moving on this. I was a no last year, but I think I'm gradually moving on this. I do agree with Delegate Embry, and I've mentioned this to you, Mr. Chair. It seems to me we need to look at a series of things that we might carve out this exception for, and not just this one thing, but that's the bill we have in front of us. But I really think as a committee, we need to figure out those things. To Delegate Arakan's point, there are other things that we should also be looking at. But at this moment, I'm moving closer to a yes.
Okay. Delegate Grammer, second bite, quick.
Yeah, and I would just, Lauren she brought up a big point. Like, as soon as we open this, we're getting away from like the admissibility question, because that is a broad concern. If someone has committed a crime, there is a recording. The other bill allows for the most probative information to be admitted. What you're actually doing here is opening two-party consent itself. So like, there are a lot of things that are frankly really tough to even understand what's happening. What about like domestic abuse? Like, aren't there legitimate concerns? And if it's not an admissibility question, we really do not, we don't serve abuse victims well. How about fraud? Like that kind of thing. That's why, my bill's actually similar. A lot of the people that have had concerns with this bill have had concerns with my bill, but it gets away from the kind of enforcement mechanism. And my bill allows people to issue probative evidence for crimes. This is The first time you're going to give some enforcement authority, enforcement
So if we could change
authority.
it in words.
Delegate Toles, your
Delegate
mic's on.
Toles, you're got to mute yourself.
Oh, sorry.
Yeah, this is different in that you're allowing an enforcement authority to wiretap. And that is a huge difference. So I don't have any questions. I see the housing folks are on. I don't have any questions. I just wanted to make that point.
Okay, I'm gonna let I see that Hugo is and Aaron are both chomping at the bit. I'm gonna give you each a minute to talk, but let's get asked. Why don't we have you guys just real quick, and then we can let other folks have another bite at the apple.
Hugo, you want to go first?
Yeah, no problem. Hugo Cantu here on behalf of Apartments and Office Building. I think it was mentioned earlier, and I think it's a great point, and that there are other methods of testing. DC has one-party consent. Based on the cases that we've reviewed, we know that there are other ways of testing. A second point really is just that lack of training. I think that was also mentioned. I think the bill specified, at least 2 years. I think when you get into the turnover of a organization or anything like that, you're going to have to fall into that retraining situation. And I think that's something that I think it's a fair and valid concern and something that the committee should take into consideration. And then, that can of worms, right? That slippery slope. Why not other types of housing discrimination? If we're going to go this route, why not real estate appraisals, fair lending, that direction? So that's my point, and I'll leave it to Aaron.
Yeah, Mr. Chairman, I would echo what Hugo said. I would also say, as I said in the hearing, the Maryland Commission on Civil Rights had a legislative audit where there were, for fiscal year 2023, the number of total civil rights complaints were 661. Only 167 were related to housing. So I'm not sure what the problem we're trying to solve here is. This seems more like a fishing expedition than anything else. And as I've said at the hearing, and I'll say it again, housing providers feel unbelievably targeted under this bill when you're going to open up the exceptions to the two-party consent law for a civil infraction for the first time ever. It's unprecedented. And even in California, that's a two-party consent state. The sponsor had a bill very similar to this bill that he ultimately withdrew when he recognized how unprecedented this bill is. So for those reasons, we strongly oppose this bill. You're going to have, going forward, if you pass this bill, you're going to have all-day hearings of advocates coming in asking for exceptions to the wiretap statute, all-day hearings late into the night for the Judiciary Committee. I know you're used to it, but you'll have even more of them. I guarantee it.
Great. Thank you. Delegate Conaway has not spoken on this bill yet. Then we'll go to Delegate Arikan.
Thank you. I was wondering, and judiciary, sometimes we're into the morning too, so make sure you know that. We want to talk about it. But what about the use of spy glasses and non-law enforcement body cameras? Delegate Grammer, you have any comment about that?
Well,
yeah, that's exactly point in case. This is what that would do. You're affirmatively allowing them to use recording of audio. So, you wouldn't actually have to announce, right? You wouldn't have to say, just so you know, the nonprofit for housing affordability is recording this call. You could just walk in with spy glasses and record because the law allows for that. That's the point in case. So great question.
Well, can they put up a sign to say no unauthorized recording?
I don't know if you can actually ask me questions, but I'll defer to the chair.
Actually, ask your question in front of the chair. Sorry. Thank you, sir. I was asking for you.
Go ahead, Delegate Arikan. That's good. That's a great question, Delegate Conaway.
So I just want to make sure it's clear. I did bring up the fact that we have a lot of other really serious criminal actions, and those bills actually concern me as well, and for the reasons that often the DV community brings up, which is that sometimes, if you have a carve out like this, the actual victims can end up being further victimized because both parties in this situation would now be allowed to record with one party consent. So I would say, why not this bill? Why would we not allow every single potential participant in an interaction to have the same access? So not only is the person investigating permitted to one party consent, but let's have it so every property manager or every single person who's interviewing for an application, they can just willy-nilly one party consent and record every single person that walks into their office. That would be more fair, I think. So I think this bill is really terrible.
Is that allowed under the bill?
No, I don't believe it is, and I don't believe it is. No, but that's an interesting idea. Okay, good. Well, I'm glad we had this conversation, Claire. I'm sure that you took all kinds of amazing notes, and we will revisit this at some point. Thank you very much, Hugo. Thank you, Aaron, for coming in and helping us understand the bill. I'm going to go back. We have 5 more minutes. Let's talk about Delegate Forbes' bill, House Bill 261. This is a bill that would change the priority of, and then I believe that the registers of wills might still be on. If they are, they can come back in if they want to. This bill would unpaid child support is part of in estates in the distribution of estate assets. It's part of number 11, which is everything else. And what Delegate Forbes is proposing in this legislation is that it gets prioritized, I believe, to number 6 or number 5. Holly, maybe you can remind me which.
Number 6, you were right.
Number 6. I can actually look at the bill. It's sitting right in front of me. I can tell you. I had some questions for. I'll just start with. I had some questions for Delegate Forbes about, why we believe that, paying somebody's wages or salaries. So if somebody did some work on the house, and should child support go before the person who just did work on the house, or rent, that the rent owed to the landlord, why child support should go in front of that. I mean, and Delegate Phillips made it clear that it's a public policy question as to how do we prioritize it. And I agree. One of the issues that I had with the bill at this point is that none of those people really had an opportunity to testify. And we did get, I sent at least one letter from sort of the, I don't know if it was from the real estate people or from the credit card people or creditors, but saying we would like a chance to be able to talk on this before you make any decisions. I sent that to the subcommittee. I'm assuming you guys got that. So that's, so my thought was, and then I'll have Delegate Arikan, is perhaps we do prioritize it, but at this point, maybe we prioritize it as number 11 and put number 11 as number 12, so that we don't have to then have all the other folks kind of check in and scream and yell, no, don't prioritize it above us, but yet it is prioritized above everything else. And then in a future year, we can have a policy debate as to whether it goes up to number 6, up to number 5, up to number 4, up to number 3. I mean, maybe our policy debate comes with child expenses is more important than funeral expenses, and it goes all the way up to number 2. So that's my thought. And it would require an amendment, which
I drafted that, Delegate Cardin. It's in that email.
Which was drafted. That's my thought. I'd like to have, so our talk can include that. I thought that was a reasonable way of dealing with this and giving them sort of at least a foothold, but not yet prioritizing it above where other people didn't have a chance to weigh in. Delegate Arikan.
Thank you, Mr. Chair. Is Delegate Forbes on the call? Can I ask her questions?
She is not. And let me see if I can, while we're talking, I'm going to text her and see if she wants to.
Cool. Yeah, because I mean, I like the bill. I see her justification. I hear that third parties now want to weigh in. My gut as a type A person is that they need to be on the ball. they know we have a 90-day legislative session. They need to be reading bills like, you know, many of other advocacy organizations stay on top of reading bills so that they know if they're going to be impacted. It's grueling work, but for those of us that worked in policy before we were elected, that's the grueling work you have to do to make sure you don't get screwed. So I don't know that if she doesn't want her bill butchered, I will err on the, on the sponsor's request. If she's okay with that amendment, then, I will defer to the sponsor, but I like the bill as is, frankly, and I wouldn't want to see it edited unnecessarily just because a couple people didn't do their homework in time.
Okay. 1 second. I'm trying to get her in while I'm doing this. Yes, Delegate Grammer.
Yes, Mr. Chair, as a member of the Civil Subcommittee, we get to deal with these thrilling issues like the order of claims of estates and trust. So I just wanted to say, rather than punt, we should probably debate the issue. And for the record, I kind of like how the bill's drafted.
Okay. All right.
Um,
Okay. Yes, Delegate Phillips.
So, Mr. Chair, I thought that the testimony was pretty clear that this was being based on kind of the federal process, and we were moving this up the ladder similarly to federal proceedings. So I think there was really a basis for this. And for that reason, I'm supportive of the bill as drafted.
Okay. Okay, great. Delegate Conaway.
Thank you, Chair. Just to be clear, do the funeral expenses come before the unpaid child support?
Yes.
And there's no limit on the funeral expense?
I have to check that, but the the order is the fees due to the register, the costs of the administration, and number 3 are the funeral expenses. But let me see if there's a cap. Hold on.
If I could offer a point of information.
Sure.
There is a cap. I don't remember what it is today, but there is a cap.
Yeah, I think that the funeral, so
Grand, 20 grand.
the costs.
All right. Alexis is here to answer.
Aye. So the question about funeral expenses is that it really depends. If the person dies testate, then which means they have a will, they can say, I'm authorizing any amount of funeral expenses. If that doesn't happen and they're above $10,000, they have to file a petition with the court for more money. But basically it's unlimited. So all the funeral expenses would be paid first.
So then there is no cap.
Yeah, basically there isn't, but if it was $100,000 funeral and the whole estate value was $101,000, the court might say, that's a little excessive. There is that option, but it rarely happens.
Okay, but I just need to know what the facts are so I can find the truth. Thank you.
Mm-hmm. Yes, Delegate Williams.
Yeah, I just was going to ask about, I see there's a Senate cross file. Do we know what's going on with the Senate bill? Is that one, it looks like it's in the same place as the House bill. And I'm kind of like where kind of Delegate Arakan and Grandma are, surprisingly enough. Like, let's just move it. I don't, yeah.
Okay.
Second.
All right. Well, I wasn't actually going to move the bill today only because I wanted everybody to look at the potential.
Sorry, I had stepped away for a minute. So
the fact is that you guys aren't interested in the amendment. I will tell you that I do worry that you will. I mean, I guess they can deal with it over, somewhere else. But
Mr. Chair, point of order. There's a motion and a second.
I understand. Yeah, originally said we weren't going to vote on this bill, and then you guys decided to move it and second it.
Sorry, I missed the memo, Mr. Chair. I
That's all
apologize.
right.
I stepped away.
Look, you can
I
see
mean,
we're all, you know,
if
this
we
is
wanna debate
this
the
is an
motion.
organic organization, and we unlike Delegate Erican's friends in Washington, we actually work as a democracy here. All right, so I'm fine. Let's take the bill up. All those there's a motion for it to be clean. Yes, Delegate Conaway.
I understand what you're saying about the organic, but some people don't eat organic, so don't go into. I mean, I'm not with that comment, so that's
You
all.
like pesticides on your, okay.
Right.
Yep. All right, Mr. Chair, you got the motion on the floor in a second.
Like
Yeah.
some people, it's toxic.
All right. Does anybody have any other comments? All right. Anybody all those in favor of the bill? Anybody opposed?
You can bring up board chair.
All right. And
I'm an aye. Sorry.
I'm
an aye.
I'll just put my note that I believed we should have held it because I wanted to work my amendment, but look, you guys didn't want my amendments. That's fine.
We
Okay.
still love you though.
Yeah, I mean, if they really that concerned, they can fix it on the
Look,
Senate
believe
side.
me, I would have held the bill if I was that worried. Okay. Good. All right. That's it. We're not gonna have time. We don't have time to talk about 74. We will discuss 74 and Embry's bill at the next subcommittee meeting.
Have a good weekend.